Further, my lords, my lady, he said that she did this to prevent public participation. My lords, my lady, there is no such information pertaining that in this affidavit. The correct version of events, my lords, my lady, which council was well aware of, was that petition E014 of 2024 was filed on 2nd of October 2024. Orders emanating from it were issued on 3rd of October 2024. As a matter of fact, paragraph 43 of this affidavit, dated 21st October, paragraph 45, indicates, and allow me to read it for you, that additionally, public participation was conducted in all constituencies through the constituency offices and county women representative offices on 4th and 5th October. There is no rational argument that can be made that then that petitioner closed her office, rushed to court to obtain court orders after declining or closing her office so that public participation could not take place. The timeline of events simply does not add up. My lords, my lady, there is no confusion or mistake that counsel could have made because it is contained in his affidavit, the one that he was referring to, sworn by the second respondent. He further submitted that during the public participation, the entire country was peaceful. And he said, with the exception of Kerugoya in Kirinyaga County. He also told this bench that the National Assembly did not experience any other issues of violence. But the tension was so palpable, the magnitude of it, that he needed to be escorted by police officers to access Kerugoya town. My lords, my lady, that information is not contained anywhere in this affidavit. Further, I refer you to the report by the National Assembly, dated 8th October 2024, paragraphs 263 and 262, which details the areas or constituencies where violence was experienced. The counties highlighted, allow me to read for you, where political interference was noted: Bomas of Kenya and Murang'a County. Counties that experienced violence: Olkalau in Nyandarua County, Kipipiri in Nyandarua County, and Nyeri County. Those names certainly do not sound like Kerugoya or Kirinyaga County. It was his intention to mislead this court so that he could take away from the credibility of the orders emanating from E014 of 2024. For the record, and just for the public that is watching us, I have never instigated, funded, organized, or even supported violence, not only in Kirinyaga County, but anywhere in this great republic. Council was aware because that information is contained in his annexures. My lords, my lady, Kirinyaga County was peaceful. It was not violent. And Kerugoya was not violent either. Further, to support that, on page 340 of that report, the report by the National Assembly, dated 8th October 2024, indicates that public participation went on at Kirinyaga Central NGCDF with 14 people participating, and further details the outcome of the same. It therefore was misleading to this court, and it was malicious and intentional. My lords, my lady, I humbly submit.
My lord, that was, excuse me, Honorable Jerry Minor had asked for time to speak to that particular issue. Then now for the third petitioner, we have two advocates. That is me and Mr. Wainaina. I had sought 1.5 hours, and that is why I sought to make a proposition that we would like to take the proposition given by the bench earlier, that given the amount of time we need to do our submissions, we're happy to do written submissions, rejoinder submissions, though we beg to be given 5 minutes for Mr. Wainaina, 5 minutes just to handle one particular issue. On my part, I will do written submissions, if that is acceptable to the court. Yeah.
My lady, my lords, my name is Mr. Wainaina. I have been sitting back there throughout the proceedings and taken quite a lot of notes. I looked at my notebook and I realized that I have about 15 issues I would have wanted to raise that came out from the submissions of the respondents. But then I narrowed them down to just 2 issues. The first one relates to the question of power. The second one relates to the question of immunity. It is important for this court to appreciate the context in which these impeachment proceedings have happened. And the context that I'm talking about relates to the question of accountability when it comes to the 3 arms of government. So you have impeachment as an instrument or a function of parliament to bring about accountability of the presidency. You have judicial recall as an instrument of bringing, not judicial recall, a parliamentary recall as an instrument to bring about accountability of parliament, and the tribunal route when it comes to the judiciary being brought into accountability. I've listened to submissions on the question of separation of powers, and what has caught my attention is how the 3 systems of accountability play out in this society. So Parliament has submitted before this court that you can conduct impeachment, or Parliament can conduct impeachment based on its standard, laid out standards. I want you to reflect on what has happened when there was an attempt to pass laws related to recall, which relates to accountability of Parliament. When the Election Act was brought about, Section 45 and Section 46 totally required that for any member of Parliament to be recalled, judiciary would have to participate. An order from the court would have to be acquired first. Then you are told that in impeachment, court has no role because of separation of powers. But in recall of members of Parliament, court has a role. There is no equality when it comes to that question of accountability, that presidency, you do not need courts, but parliament, you need the court. It is very interesting when you look at the amendments that were made on the Election Act through a bill that was submitted by the Senate, Bill number 29 of 2024, that sought to remove legal justification for recall completely. And so when you consider the question of power, Parliament is simply telling this court that we have the power to do anything because impeachment is our function. But when it comes to judicial review, you should be restrained. That doesn't make sense. In fact, Parliament has gone ahead and sought to limit even the provisions of Article 1, where the sovereign, the people, are given powers to exercise their powers directly by enacting Public Order Amendment Bill of 2025 that seeks to control how Article 37 is exercised in this country. And so Parliament is saying that we have the power even to govern the people themselves in the manner that they would exercise the powers of directly. But when it comes to us as Parliament, do not touch. And that is why there were submissions related to the question of judicial review, whether it's going to dig into the merits of this case. I find it interesting that when it comes to members of county assembly, the County Government Act, Section 27, says that you can recall a county member of parliament, a member of county assembly, only upon a judgment or finding by the High Court. If these accountability measures that have been provided by the Constitution seeks to limit the power of the court, why is it that then when it comes to county members of assembly members, a court has to participate, but when it comes to impeachment, the court is limited in one way or the other? That's the context that these impeachment proceedings are before you, and it is very important to see the power play that Parliament is actually engaging in. Parliament is claiming immunity, and that immunity, from my view, is trying to put this court under limitations on the question of judicial review. My lady, my lords, Article 10, looked at from the set theory, has certain elements of values. And one of those elements is that of accountability. And there is nowhere that accountability is classified as to whether it's political accountability, economic accountability, or social accountability. It is simply accountability. Such that when you talk of accountability, then it is within its breadth and width. It is not limited in any way. And therefore, all the submissions related to that question, this court must be allowed to exercise judicial review in its entirety. And judicial review in this case must include rationality review. Were those decisions rational? Review of evidence. I listened to submissions from one of the councils the other day, and we were told that 281 members of parliament voted for this motion. What I find interesting in that submission is that you are given the impression of how overwhelming the support was for the motion. But there's something that you're not being told. That never before has Parliament has such numbers when it comes to performing their primary function, which is legislation. my lady, my lords, I find it interesting that 5 times the public participation bill has failed. The first attempt was in 2016. I invite you to just consider those bills. 2016, second attempt in 2018, third attempt in 2019, fourth attempt in 2023. It never passed. The recent one is in 2025. It is very interesting when you look at all those bills and you see the departure pre-impeachment and post-impeachment. The 2025 public participation bill, interesting enough, seeks to say that once public participation is conducted by Parliament, then the Senate may just adopt whatever has happened in the National Assembly, which was not the position in the previous bills. And so, my lady, my lords, we have a Parliament that is seeking to benefit from things that it has failed to do. If you go to Schedule 5 of the Constitution, you will realize that the timelines were very clear. Public participation bill was supposed to have been passed within 3 years. The right of recall was supposed to have been passed within 2 years. None of those things have happened. And at one instance, you find Parliament is able to mobilize 281 members to just vote for impeachment. In other words, when it comes to accountability of presidency, the numbers are available. When it comes to passing and performing the legislative functions, numbers are not available. There is an indictment on Parliament, even in the impeachment proceeding itself. Out of 11 grounds that were submitted to the Senate, 6 of them failed. In other words, 281 members of Parliament passed 11 grounds that could not meet the threshold when it came to the Senate. 221 members of National Assembly. Is the attempt to curtail the powers of this court on judicial review out of fear that the remaining 5 grounds will totally fail. Maybe that's what is driving this question of power. I want to conclude by mentioning a statement that was made by Isaac Newton back in the 17th, 18th century or thereabout. An accomplished scientist. Isaac Newton lost half of his fortune after investing in a pyramid scheme, what we call in modern day language pyramid scheme. And this is what he said, that I have calculated the motions of heavenly bodies, but I have not been able to calculate the madness of people. The drafters of this constitution calculated everything that they could, where to place the word shall and where to place the word may. They calculated which institution would have which powers. But I submit before this court that it seems that they had not anticipated the madness of people who are seeking to overthrow the constitutional order and take this country, the Westminster parliamentary kind of democracy. We are a constitutional democracy. And any attempt to take us in that direction, where Parliament becomes the most powerful institution in this country, as compared to the Constitution, that attempt must fail. In making your decision over this impeachment matter, my submission, my lady, my lords, is that this court must reflect on the exercise of powers by Parliament, because in impeachment, it is the one instance where Parliament is both, not even both, performs investigative powers, which ordinarily are with the Inspector General. It performs prosecutorial powers, ordinarily under the ODPP. It performs adjudicative powers, ordinarily are with the courts. It goes ahead and actually conducts public participation, more or less like an administrative. And yes, these powers are provided, but these powers are not provided with without limitations. There are constraints that are required, and those are the constraints that you're being told by the submissions of National Assembly and the Senate that you should not look into. When you're told not to look into merits, you're being told, we have power, but you and your powers are secondary, or your powers are not at the same levels as ours. I invite you to exercise the full breadth of judicial powers in examining even the grounds of this impeachment and the evidentiary threshold that was provided. For that is our submission. And I conclude by saying this. If this petition fails, I am worried as to the future of this country. We've been told that we may get into constitutional crisis. And I think we've been in a constitutional crisis for the last 16 years. This court should not allow that constitutional crisis to be interpreted by Parliament the way they want to do the interpretation. And that is, my lady, my lords, my humble submission.
My Lord, perhaps just to put one request on behalf of the respondent. My Lord, the parameters of Rejoinder are well known. And some of our colleagues who are responding for the issue are straying outside the limits of that Rejoinder. If I may conclude. And the danger with that, my Lord, is that it is prejudicial in that the respondents do not have an opportunity to respond. Rejoinder, I believe, is an opportunity to respond on issues of law that have arisen in the response by the respondents. It is not an opportunity to plug any holes that have been made in the response. That happens in the ordinary course of litigation, and we all know that your lordships and your ladyship will resolve those issues as you should. So my request, my Lord, is that the rejoinders be confined to what a rejoinder is. And it is not an opportunity to relitigate or to shore up any leaking holes that have been left. Most obliged.
I think point is well noted. And,
do I have a right of reply to that? Which is something I was anticipating. Well guided.
Mr. Muge.
No, yes, my Lord.
You say you want 5 submissions now.
Yes, Rejoinder submissions.
You find them within how long?
2 days.
Today?
2 days. So that will be by Tuesday, today being Friday.
Find the submissions within 2 days.
Much obliged.
Your Ladyship, on behalf of the 4th to the 8th
petitioners in this matter, we wish to respond specifically to the respondents insofar as the political doctrine question and public participation is concerned. With regards to the political question doctrine and emanating from the submissions by my learned senior, Professor Githu Muigai, Professor Rejoinder, and my good friend and brother, Mr. Gumbo, we wish to say this, that impeachment is a legal process. The origin of impeachment in terms of Anglo-American law is the Good Parliament of 1376, and that history points to impeachment being fundamentally a legal idea. That is one. On the political question doctrine, we are of the opinion that your ruling, your very first ruling in this matter, settled that question. And to remind ourselves of the principles governing the political question doctrine, let us remember that the political question doctrine draws from American Supreme Court jurisprudence, and in specific, the case of Baker versus Carr. And this case announces 5 principles. Number 1, that a matter is not justiciable because it is demonstrably committed to another branch of government. Number 2, whether there is a judicially discoverable and manageable standards for resolving the matter. Number 3, whether it is impossible to decide the matter without making an initial policy determination of a kind meant for non-judicial discretion. Number 4, whether it is possible for the judicial branch to make determination on the matter without expressing lack of respect for the political branches. And the 5th principle is the multifarious pronouncements by various branches of the government on the same question would be embarrassing. I don't want to belabor what my teacher, Professor Muigai Akech, ably helps this court with from page 419 of his text, Administrative Law text, Strathmore University Press, 2016, 419 to page 423. Professor Muigai counters the narrative of the political question doctrine and its applicability in Kenya. Specifically, these factors have stirred controversy even within the U.S. context. So if they stir controversy within the U.S. context, why would they be applicable to us? That is one. The political question doctrine purports to create a dichotomy between political and legal questions. In the U.S. context, as evidenced by Professor Muigai Akech, the U.S. Supreme Court itself has consistently invoked prudential and constitutional factors in its determinations. So legal factors are front and center in determining what are so-called political questions. The Baker factors that inform the political question doctrine make an unrealistic assumption that there is an existence of political and legal questions that can be neatly separated in the context of litigation before this court. We say no. The political question cannot be applicable within the context of the Constitution 2010 for the following reasons. Number 1, this Constitution, the Constitution 2010, creates a supervisory jurisdiction for this honorable court, and that supervisory jurisdiction anchors not only on Article 165, but is anchored also on Article 1, Article 2.1, Article 3.1. So if courts decline to decide cases on the basis that they are political, courts will be abdicating the very role that their Constitution, our Constitution, imposes. The Constitution expects the courts to review all exercise of public power, including politically sensitive ones. For that regard, I refer the court to the lead decision of Professor Justice Joel Ngugi, as he was known then in the Devin D decision. He emphasizes that point. Second reason why this doctrine is not applicable to the Kenyan context: this doctrine is incompatible with the broad discretionary authority, jurisdictional authority rather, granted to this court under Article 165. So anything done under the authority of the Constitution, including impeachment, including actions of Parliament, the President and political actors, are amenable to review. There is no constitutional exception for political questions. Number 3, the tenor of the Constitution 2010 indicates that we are dealing with a transformative constitution. And transformative constitutionalism rejects judicial abstention. Kenya's constitution has been widely described as transformative. It is meant to dismantle the history of the executive dominance, impunity, and weak judicial oversight. Before 2010, it would have been prudent for the courts to avoid politically sensitive disputes. The executive power was rarely checked. After the Constitution 2010, the Constitution deliberately expanded access to courts through Article 22 and Article 258. Standing rules were relaxed to ensure that all matters, including political questions, are amenable to judicial review by this court. To allow or to even countenance the political question doctrine would be to recreate the pre-2010 culture of judicial avoidance that the Constitution sought to end. The fourth reason, the Bill of Rights demands that judicial enforcement happens against the state. Article 20 of the Constitution requires that courts apply the Bill of Rights to all law and to all state actions. Human rights violations always arise from political decisions, elections, public finance, security policies, legislative processes. So if courts were to label such issues as political, fundamental rights will become unenforceable whenever violations arise from political power, undermining the Bill of Rights. So in examining the impeachment process, there are rights questions that are involved, and the Constitution empowers you to exercise judicial review. The fifth reason why that doctrine is inapplicable is separation of powers in Kenya requires judicial engagement and not abstention. Kenya adopts a checks and balances model, not strict separation. The judiciary is designed as an active counterweight, and the Constitution explicitly allows the court to do the following. Number 1, review parliamentary procedures. That is empowered under Article 124, Article 165. Review presidential actions, to issue orders against the state. That is by our Article 23, which is our remedial clause. Thus, the judicial review is a structural component of separation of powers, not a violation of it. Sixth, constitutional design anticipates politically sensitive disputes. The Constitution directly assigns the courts the role to delve in deeply political processes, such as political election disputes, which are political, impeachment processes, governors, and the like. The courts are allowed to delve into them. Constitutional amendments, we dealt with this during the BBI. Public participation in legislation, these are politically sensitive issues that the court is allowed by the Constitution to delve into. So if it was not intended for the courts to delve into, these items will not have been explicitly placed in the court's hands at the center of these processes. The court will not have been allowed by the Constitution to delve with these issues. Number 7, popular sovereignty requires judicial enforcement. Under Article 1, all power is delegated by the people. Courts act as referees, ensuring that delegates remain within constitutional limits. When you conduct the process of impeachment, and we say that impeachment is a constitutional process, a constitutional interrogation, you are exercising power that is delegated to you by the people. And therefore, if courts refuse to decide political disputes, there is no neutral guardian of the people's sovereignty under Article 1. Political branches will become judges in their own cause. That outcome contradicts the entire constitutional architecture. So, finally, and in conclusion, with regards to the political question doctrine, the Constitution mandates judicial review of all power. All power. It entrenches transformative constitutionalism. It constitutionalizes public interest litigation and broad standing for the purpose of checking power. It assigns the courts roles for engaging in politically sensitive processes. And finally, it requires this court to enforce the Bill of Rights against the state. Public participation. Public participation is a public engagement that is enshrined as a national ideal and a governance principle under Article 10(2) of the Constitution. This clause emphasizes the necessity of engaging individuals in decision-making and guarantees that their perspectives are taken into account on issues of public significance. Public participation has also been incorporated into domains of governance, including Article 69, which mandates the state to promote public participation in the management, protection, and conservation of the environment. Article 118 mandates Parliament to promote engagement and participation in its legislative procedures and other parliamentary activities encompassing functions of its committees. Therefore, public participation cannot and is not a procedural formality that can be exhausted by one institution on behalf of another. It was the position of the Senate that the Senate did not need to conduct public participation after the National Assembly had done its bit. We say this, that public participation is not a procedural formality that can be exhausted by one institution on behalf of another. Rather, it is a constitutional principle embedded in the architecture of governance under Article 10(2) of the Constitution. And as a national value and principle of governance, public participation binds all state organs whenever they exercise constitutional authority, including the Senate. Consequently, the Senate could not and cannot validly argue that public participation conducted by the National Assembly was sufficient to satisfy its own constitutional obligations during the impeachment proceedings against the Deputy President. The National Assembly and the Senate are distinct constitutional organs with separate mandates, separate procedures, and deliberate responsibilities. So while the National Assembly initiated and investigated impeachment proceedings, the Senate was expected to exercise independent adjudicative and oversight role in determining whether the charges warrant removal from office. And since the Senate performs a constitutionally distinct function, it must independently uphold the constitutional principles governing the exercise of public power, including public participation. With regards to public participation, we had presentations here on the BAT case, equally on ex parte Gakuru, which denote two tests, the qualitative and the quantitative tests. In terms of the qualitative aspects of public participation, we pose the following questions, and we will want this court to examine whether the respondents really complied with the qualitative and quantitative tests of the Constitution, because case law from this court and the Supreme Court demand that those who conducted public participation must prove to your satisfaction that public participation mastered qualitative and quantitative aspects of it. So the following questions in terms of degree of inclusion. In the Gachagua impeachment case, these are the following questions. Were all constitutionally relevant stakeholders afforded a real opportunity to participate? That is the first question that this court should consider, based on what the respondents submitted. Second question is, were any groups directly or indirectly excluded, restricted, or unable to participate? And on the question of participation, the follow-up question is this: did the stakeholders get all the necessary information to capacitate their involvement in the public participation forum? Did they know what they were participating in? That is the third question. The fourth question is this: did any stakeholder voluntarily decline public participation despite being given the opportunity a fair opportunity to participate? Those questions will be important for this court in the context of public participation. And public participation not only has domestic constitutional connotations, but Article 25 of the ICCPR, the International Covenant on Civil and Political Rights, demand that citizens must be involved in matters governance, that it necessitates public participation in the dimensions required by Article 25. Information given to them, their feedback given, their input taken into account. As I wind down, this court will be engaged in constitutional reading and interpretation. Chief Justice Brian Dixon of the Canadian Supreme Court, dealing with one of the first questions after the enactment of the Canadian Bill of Rights in a case called Hunter versus Southam Inc., 1984, said this: that the task of expounding a constitution is crucially different from that of construing a statute. A statute defines present rights and obligations. It is easily enacted and easily repealed. A constitution, by contrast, is drafted with an eye to the future. It functions to provide a continuing framework for the legitimate exercise of governmental power, and when joined by a bill or charter of rights for the unremitting protection of individual rights and liberties, its provisions cannot easily be repealed or amended. It must therefore be capable of growth and development over time to meet new social, political, and historical realities, often unimagined by the framers. The judiciary is the guardian of the Constitution and must, in interpreting its provisions, bear these considerations in mind. That is Chief Justice Brian Dixon, one of the celebrated Canadian judges in Hunter, Southam Inc., 1984. As Chief Justice Brian Dixon observed in this matter, the Charter of Rights and Freedoms, jurisprudence, a constitution is not a transient political instrument fashioned for the convenience of the moment. It is a living covenant designed to endure beyond the passions, the pressures, and the personalities of a particular age. Its guarantees are intended to outlive political majorities and to restrain the exercise of public power whenever expediency threatens constitutional fidelity. that duty falls most heavily upon the court at moments such as this. The question before this court is therefore larger than the fate of any individual office holder. It concerns whether constitutional safeguards governing impeachment shall remain meaningful limitations on power or become pliable tools vulnerable to political dissatisfaction, procedural shortcuts, or majoritarian impulse. If the constitutional threshold for impeachment may be lowered whenever circumstances become politically convenient, then the protections deliberately entrenched by the Constitution cease to be safeguards at all. They become ceremonial words devoid of normative force. Impeachment is among the gravest constitutional mechanisms available within a democratic order. Its exercise must therefore be anchored on strict fidelity to the Constitution, demonstrable evidence, procedural fairness, and scrupulous observance of constitutional standards. Anything else, anything less, not only imperils the independence of constitutional offices, but also public confidence and the rule of law itself. The Constitution does not permit removal by atmosphere, speculation, public pressure, or political arithmetic. It demands proof, legality, and constitutional discipline. This court now stands as the ultimate guardian of that discipline. Posterity will not merely examine whether a removal occurred, it will examine whether the Constitution survived the process intact. It will examine whether the Constitution survived the process intact. Future generations will look to this decision to determine whether constitutional restraints remained firm when tested by political urgency or whether they yielded to transient pressures. The enduring legitimacy of constitutional governance depends upon the court demonstrating that constitutional procedures are not optional and constitutional thresholds are not elastic. Accordingly, where the impeachment process fails to satisfy the substantive and procedural standards demanded by the Constitution, the court must say so clearly and without hesitation. To do otherwise would not merely occasion an injustice in the present dispute, it will establish a precedent capable of weakening constitutional democracy for future generations to come. The correct decision, therefore, is the courageous one, to uphold the supremacy of the Constitution over convenience, principle over pressure, and the rule of law over the impulses of the moment. I submit.
Lord, if the tomorrow is taking 10 minutes, it is easier he speaks fast. He comes from a community that they say is marginalized.
Yes. And my lords, I'm fighting for that space so that I'm not marginalized even before you.
10 minutes.
Yes. My lords and my lady, my name is Ole Kamwaro. I'll be very brief because brevity and precision are demanded when the Constitution itself has been violated with such present clarity. My lords and my lady, what stands before this court is not a matter at the margins of constitutional law. It is a matter at its very core. The impeachment of the first respondent, His Excellency Rigathi Gachagua, as the Deputy President of the Republic of Kenya, was not merely procedurally flawed, it was a constitutionally hollow, it was legally fraudulent, and this court must say so plainly and without equivocation. My lords, the respondents have spoken before you and submitted before you, but there are pertinent questions that have not been answered and put across satisfactorily before this court. The question is, where in any court or in any proceedings before any competent authority has it ever been determined that Honorable Gachagua committed the offense of hate speech? The answer, my lords and my lady, is nowhere. And yet, on the basis of that phantom finding, a deputy president was stripped of his constitutional office. That, my lords, is not governance, that is purge. Let me now go to the issues and offenses under Section 13, 1A of the NSAIC Act. And I'll start by saying that the allegation of hate speech is a legal nullity dressed in parliamentary robes. My lords and my lady, Section 13, 1A of the National and NSAIC Act is not ambiguous. It requires a sine qua non words or conduct that are threatening, abusive, or insulting, and that either intend to incite ethnic hatred or likely to do so. I submit that both limbs must be satisfied. The respondents who spoke before you have not satisfied any of those limbs. The first petitioner's remarks, in part remarks that has rattled so many, on the issue of that majority of the people who voted for the Kenya Kwanza regime have a legitimate expectation of participation in structures, in state structures, are on any plain reading a political metaphor. A metaphor about democratic accountability. A metaphor that if one were to apply intellectual honesty to it, actually advances a thesis on the relationship between electoral mandate and governance access. One may disagree with that thesis that I submit, but disagreement with a political viewpoint, my lord, has never and can never be hate speech under any known law in the Republic of Kenya. My lords and my lady, where is the ethnic group that was threatened by the impunged speech of Honorable Gachagua? Where is the community that was insulted? You have not been told of any community. Where is the finding of ethnic animosity? My lords and my lady, there is none, because none exists. The impunged speech named no tribe. It targeted no ethnicity. It incited no violence. To address it in the garments of Section 313 of NSAIC Act is an insult, not to any ethnic group, my lords, but to the law itself. And consider this, the National Cohesion and Integration Commission, my lords, is the body vested by Parliament under Section 25 and 26 of NSAIC Act with exclusive mandate to investigate, summon, and recommend prosecution for violations of Section 13. It's very conspicuous, deafeningly silent. That commission did not speak. Not one summon was issued. Not one caution was issued to Honorable Gachagua. Not one recommendation was made for his charging before any court. That very watchdog created to guard against hate speech refused, my lords, to back. Parliament chose to back in its place. And in doing so, Parliament exceeded constitutional canon. When Parliament, my lord, bypasses NCIC, and itself determines that a statement constitutes hate speech, a finding it has got no jurisdiction to make. It does not merely my lord, it usurps. And usurpation of constitutional or legal function is precisely the kind of excesses that Article 165 of the Constitution vests in this court to strike it down. My lords, the charge of hate speech under the sections that I have referred to is hypocrisy. selective justice, my Lord, is not justice at all. My Lord, the respondents prosecuted the case against Honorable Gachagua for allegedly promoting preferential treatment on the basis of political identity. And yet this court must make judicial notice, and is entitled to do so, and is obligated, of public record appointments made by this regime after assuming office in 2022. And I'm speaking so as a lawyer who comes from the Maasai community that is marginalized. If you look today in our affidavit that we have filed, the statistics, the number of appointments that have been made or allocated to certain communities, if you compare the Maasai nation, the Mijikenda, as against others of similar numbers, they did not tell.
My Lord, I'm just concerned. Yeah. Thank you.
Okay, most obliged. So I'm saying that we have said, we have given figures in our replying affidavit. But I'm saying even those who, the appointments that are being made do not respond with without the Constitution talks about ethnicity, regions, and diversity of Kenya. This court must ask itself, if the law means anything in this republic, can it be applied only against those who fall out of political favor, while those who hold power are exempted from it? The answer from every constitutional and jurisprudential tradition is an emphatic no. My Lord, we have submitted that Article 11, Article 56, on the issue of ethnic and cultural diversity of our country are provided for in that Constitution. My Lord, you have been told much about the doctrine of restraint. I want to say this, that legitimacy of this court intervention and why restraint is not available here, and I'll say so. The respondents have argued before you on the doctrine of separation of powers and urge this court not to interfere with the parliamentary processes. That argument is a familiar refuge for those who have exceeded their authority, for it asks the referee to stand aside precisely when rules have been most violently broken. My lords and my lady, this court's jurisdiction under Article 165(3)(d) of the Constitution is not a courtesy. It is a constitutional imperative. When Parliament has acted beyond its constitutional mandate, and Parliament has no mandate to make findings of hate speech and bypass the NCIC to remove the Deputy President on grounds that do not meet the constitutional threshold, this court is not intruding on parliamentary space. It's actually vindicating the Constitution. My lords and my lady, the Supreme Court of India, in the case of Casavananda, Bharati, and our own Supreme Court on the foundational cases on constitutional supremacy, has established beyond doubt that no arm of government, not even the legislature acting by supermajority, may override express provision of the Constitution. Parliamentary immunity for judicial review is a doctrine of legislative acts within the constitutional bounds. It is not a license, my lords, to violate those bounds with impunity. This court must intervene. Not because it is eager to do so, but because the Constitution demands of you to come and save the soul of this Constitution. In conclusion, what history will record after these proceedings today? My lords and my lady, let me close by saying this. The impeachment of Honorable Gachagua will be recorded in the constitutional history of this republic. The question is, what record will say? If this court allows to stand the impeachment, the record will say that in Kenya, a deputy president may be removed from office on the basis of political metaphor without any finding or by a competent authority and without meeting constitutional threshold, and through processes that selectively targets political opponents while exempting those in power from equivalent treatment, scrutiny. If this court grants the relief sought in our petition, the record will say something entirely different. It will say that in Kenya, the Constitution means what it says, that the threshold of impeachment is real and it is high, that the rule of law is not a slogan but a shield, available to every Kenyan, including a Maasai like me, including those whose politics are inconvenient to the powerful. We urge this court to make the right record. We pray for orders as prayed in our petition, including a declaration that the impeachment of the first petitioner was unconstitutional and an order that he be compensated as prayed. So I submit, my lords. Thank you. And always, my lord, whenever I speak and address this court, my learned colleague is my friend, always interrupts my presentation.
There was a petitioner in this matter, especially during the proceedings.
Yes, my lord.
No, there was a petitioner in this matter. Senior Councillor Amenya. I will not see him in this second arm of proceedings. Is the council well?
I have this. My lord, I think he came during the first speaking bell.
Yes, I have not seen him again, so I have no information. I think he was appearing in his pastoral capacity,
Yes.
and also for one of the civil societies. Two. Yeah.
Well, my lord, now that issue arises, he's one of the senior lawyers. I've had the privilege of calling me to tell me one or two things that have clarified some of the points we've been trying to make. He's okay. I don't want to say much, but he's okay. Yes. Now, my lords, I'm happy for the time given to my learned colleagues, Mr. Martin Kamwaro, to deal with the issues because of the time constraints that are there. I will try to speak a little bit fast. I'm assuming you are being recorded.
Yes. How much?
Yes, I should be done between 30 to 40 maximum. I should be done. My lords, and I will go straight to, I'll mention the specific submissions that I'm responding to. If I don't mention any persons, it is only because I have had to edit the response to fit the timelines that have been accorded to me. Now, first of all, I want to thank this friend of mine, Dr. Mudhomi, for mentoring this young lawyer that we had him making very good submissions. I told him he reminds me of Gibson. He mentored very many people, including myself. And I challenged my assistant, Sylvia Musongo, that if ever Professor Kindiki, who is my friend, also is impeached, he should come like Mutavia to speak to you. Be that as it may, let me come to the business of the day. And I want to clarify, Mr. Mukele had suggested that the specific orders of standing orders of the National Assembly and the Senate have not been challenged. I want just to reiterate that we did so in prayers number 12 and 13 of the re-amended petition. And the next general issue, this is a cross-cutting issue that has arisen, is the questions of may and shall in our Constitution. I will not bother the court with the grammar, which appears differently in very many decisions from the High Court to the Supreme Court. Because we are dealing with constitutional adjudication, the Constitution has already said how the Constitution shall be interpreted. And that includes the word may and shall. in Articles 20, we start with Article 4, I believe. They say Kenya is a constitutional democracy. So in interpreting the meaning of any law, that's the value that you start, constitutional democracy. Values of our Kenya are stated in Article 10. And then we have Article 24, where they say interpreting any law or statute, any intervention by Parliament, they must take into account the fact that this is a free society that believes in democracy and certain value systems. That is in Article 24 of the Constitutions. And then there is Article 259(1) of the Constitution that also says how you interpret the Constitution. So that bearing in mind those provisions, it is our submission that the context in which the word may and shall in Article 145 must be interpreted by the Constitution is by this court examining what is it that it seeks, what is the issue of substantive justice, substantive law that seeks to be secured. And my lords, I submit that the Constitution itself, when you read it, makes it clear that when the motion and the report is received from the National Assembly, Senate shall investigate the matter. Shall investigate the matter. The question is about investigations. In our earlier submissions, we said why under our system of justice and the adversary justice system, justice must be based on truth, and the investigation is how you arrive at that truth. Therefore, if that be the case, then 145 must be read in a manner that upholds that an investigation must be conducted, because that is the principle and that is the value. The issues of natural justice, they are set out in our constitutions, must be incorporated in interpreting that law. So that, my lord, there would be some danger, obviously, that if the usage of the word may, as suggested by the respondents, was to be used to say that you can actually impeach an elected deputy president without investigation, as the Constitution seems to say. Such a reading is absurd. But apart from the absurdity of it, is that it is unconstitutional on the basis of the provisions of the constitutions that we have read. But now, the only other question is a practical question, which is purely a question of common sense. My lords, why didn't the Constitution use the word shall? For the simple reason that historically, because we have imported this impeachment issue, it is not every time that when the National Assembly has impeached a president, like they do it in America, that the president would actually agree to have the trial. So what that means is that you couldn't use shall because if, for example, you are dealing with an American situation, Nixon did not go for trial. Nixon resigned. So that it becomes now an optional issue that at the time when the matter is at Senate, it would have to be dealt with in a prudent manner. What is the prevailing situation? Just like now when you are dealing with the prevailing situation, the lawyer for the first respondent are saying, though the Constitution can reinstate the first petitioner to office, they are nonetheless saying, we may not go take that office. So that, my lord, because of the possibilities of all those intervening, is the reason why you use the word may. Many statutes that I know, I've done a lot of work on these university statutes. There are very many cases starting with Subachachi. I believe I even defended Hassan Omar when they were trying to get him out of Moi University. My lord, many universities would use the word may. But the courts have over the years said the issue of whether or not you are going to hear a student or any other aggrieved person is not optional, merely because you have used the word may. May cannot take away the fact that in Kenya, natural justice is mandatory. So that what are we saying? Unless this court can say natural justice does not apply to the impeachment of the deputy president, number one, or number two, is also prepared to say investigations were not necessary, then it is not possible to read the constitutions to say that the usage of the word may meant that it is not mandatory. If we apply our value system and the principles of our constitutions, investigations are mandatory. You cannot pass a verdict minus that investigation. Apart from the issue of the doctrine of separation of powers that we talked about it, that parliaments, but I'll come to that question. Rejoinder made some good submissions. Is one of the issues we are picking up.
You are beating up.
No, just relax. My Lord, I start with Professor Gedu. I believe is the one who spoke first, senior counsel. Professor Gedu Muigai said that contrary to what we had submitted, that the Constitution makes provision for the procedure of impeachment of the Deputy President. And I wish to reiterate that it does not. Article 105 of the Constitution says the issue of impeachment of the President. Article 150 requires that you modify the procedure in 145 in order that it can apply to the Deputy President. What does this require in actual terms? I believe I asked Sylvia, what does, because Professor Muigai kept on talking about mutatis mutandis. So what does this mutatis mutandis means in plain English? In plain English it means the original exists, which is 145. Then you need to get, what is it, the generic. That's what they say. You need to get a generic. The generic in the medical world must actually exist. The generic and the original are basically the same medicine except certain ingredients. So, so there must be in existence a document.
That's not correct scientifically, but it doesn't matter.
Okay, I defer to the science. But my understanding of generic, I have a good pharmacist, is that a generic is based largely on whatever was the original drug that is supposed now is generated. Now, be that as it may, in the simpler language then, what it would mean in my understanding is that if you say you have procedure A, 145 for the president, you must be able, when you are impeaching the deputy president, on account of Article 150, to say, in obedience to the Constitution, the National Assembly and the Senate modified it this way. Because the Constitution does not say it will be done through a legislation, it means it can only be done by standing orders. Because those are the two instruments, legal instruments that can be used by Parliament to do anything ordered by the Constitutions, legislations or standing orders. My Lord, there are no standing orders that have been waived that demonstrate that a procedure was made pursuant to Article 152 of the Constitution. If that be the case, then there is non-compliance with the Constitution, what it says expressly. We needed something to be waived. But it is obvious that they could not be able to undertake this impeachment without somehow creating some procedure. And they actually did that. And it is it was annexed to the affidavits of the Senate, or the National Assembly. Annexed, I believe, number 2, what did they call it? Part 2 of an annexed bundle. Bundle number 2. It's a big bundle. I couldn't carry it here. Page 1296 and it was 1277. 1277. What did the Parliament, the Senate do? They came somewhat with a program, like those things we have for weddings, saying Gachagua will get 2 hours, National Assembly will be able to get this. And you look at it, my lords, and you ask yourself, this cannot possibly be what modification could have meant when the Constitution says. We don't know who made that program. That they say this program is the one we are going to use to impeach the deputy president. So that, my Lord, in evidential terms, there is not before you a modification that has been availed by the National Assembly or the Senate. And this explains the reason why, in America, Chief Justice Rehnquist, he has the trial of Bill Clinton for an entire month. But here, because you've come up with some kind of a burial program that ordinarily takes a day, that's how you want to impeach or conduct the trial of a deputy president. My Lord, this would subject us to be a mockery amongst nations that are proud to be constitutional democracies. So I agree with my learned friend, Professor Ogada. There are certain things, and the other gentleman who spoke, there are certain things that are simply not permissible in a constitutional democracy. And one of the most fundamental one is this one. My Lord, the next issue is the issue of timelines.
While you are still there,
yes, my Lord.
How would you, for example, if the impeachment proceedings
yes.
be modified,
yes,
or with less than moderation,
yes,
and you, because if you fail to modify, that is also the alternative, that we don't want any moderation. Is that also correct? That there may be no need for moderation.
There is no, when you look at the previous submissions, I didn't want to touch that because I would raise 1,000 objections. But when you look at our submissions, we actually explained, my Lord, because all those things, I believe Mr. Martin Kamaro dealt with it. You can charge the deputy president for all these statutory offenses. Yes, if you don't modify.
Yeah, if you don't modify, is it also an option?
It's not an option.
It's not an option.
Yes. The reason why it's not an option, I'm saying, we explained that the deputy president is not a commander-in-chief. The deputy president does not enjoy any immunity. We explained all those reasons. So you modify so that whereas you can say if the president engages in incitement, and I think he does all the time, you need to impeach him. But if the deputy president engages in incitement or hatred, there is a national cohesion and a penal code that you can resort to. So the modification allows you to be able to factor into the fact that ordinary criminal offenses, and I believe we said a lot on that, cannot be the basis for the impeachment of a deputy president. But serious theft and corruption can be used against a sitting president.